This. 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 This.
It's fine.
This. 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 You are. This. 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 Yes, ma'am. It was found at the 30. That's fine. Thank you. It was found at the 30. I'm done. Yes. Okay. Mhm. Yes.
Good morning, everyone. And welcome to the finals for the 2022 National Moot Court competition series sponsored by the Bar Association and the Judiciary of the Turks and Caicos Islands with the support of the Ministry of Education and Department of Youth. Today, we're here for our finals in this competition in which we will see the H.J. Robinson team and a team from Precious Treasures High School, International School, face off in this final round. We will invite our Mistress of Moots, Ms. Arnell Taylor, to actually walk us through the rules for today's mooting competition. Before doing so, I would like to encourage everyone, once the moot starts, that we all keep our masks on. The judges won't be wearing masks, and then advocates, when you are speaking, you are asked to remove your mask so that the judges can see your full face when you are dialoguing with them. But for the rest of us, we would ask that you keep them on during, when inside during this session. Following this, we will then gather under the tent for the award ceremony, at which time you'll be able to take them off and participate in some of the refreshments that we have. Also, before I invite our Mistress of Moots, I would like to acknowledge the presence of our Minister of Education, who is present with us today, and who has been a strong supporter of this competition of series. I would also like to acknowledge the presence of the Speaker of the House, Mr. Gordon Burton, who is here to support the students today, and also to present an award from the House of Assembly to our winners. Also want to welcome parents, want to welcome our mentors, friends, members of the Bar Association, and in particular the Bar Council, who are also seated at the rear of the courtroom. You have Ms. Sarah Knight, our Vice President, Ms. Desiree Downs, and Mr. Jermaine Swan, who are members of the council, our Secretary, Mr. Rick Quant, and our Treasurer, Ms. Shante Francis. So again, I want to thank you all for joining us today. For those of you who are joining us online, thank you. Thank you for being faithful with watching each step of the way. We've had tremendous support from our online viewers. And so we would hope that not only today, but when we return with the competition next year, that the online viewership becomes something that also continues to grow. At this time, I will invite our Mistress of Moots, Ms. Arnell Taylor.
Good morning, everyone. So my role today is to take you through the judges' assessment criteria. The following criteria will be used to assess the winners of this competition. And it is important to note that it is possible to win the moots even though you did not win the legal argument. So the development of the argument is worth 30 marks. Structure and strategy is worth 30 marks. Questions from the bench, 25 marks. And speaking ability and delivery, which means their presentation, is worth 15 marks. So for the development of the arguments, we are looking for the participants' ability and skill in applying the arguments in the moot court. We are looking for the clarity of their initial submissions, their ability to argue within the grounds of appeal, the ingenuity of the legal argument, for example, their ability to utilize or adapt apparently unconnected areas of law, their ability to withstand judicial questions by reference to the appropriate law, and their ability to adapt to a judge's interruption or question, and their responsiveness to arguments presented by fellow advocates. For their structure and strategy, we are looking for students and participants that understand the application of the legal points. We will consider the logical structure of the legal argument, recognition of legal issues, application of the law to the facts of the problem, understanding and application of the English legal method, i.e. system of hierarchy and precedent. When we refer to questions from the bench, we mean the participant's ability to articulate a response to the judge when interrupted or when a question is asked. When the judges think about the participants' speaking ability and delivery, they are considering their ability to moot without reading from a script, maintaining eye contact with judges, confidence of the mooter's delivery, posture while speaking, and respectfully sitting quiet while the opposing team are speaking, court etiquette, which includes referring to the judge correctly, courtesy towards the judges, and correct names when referring and respectfully referring to their fellow advocates. So we would now call our president of the Bar Council back to read the hypothetical case to be argued before we rise.
Thank you, Ms. Taylor. For the benefit of those present here and for those joining us online, I will now read out the moot court problem that our advocates today will be presenting before the court. Percival Major High School is a well-resourced school on West Caicos, located on Percival Major Drive in Yankeetown. The school was built in 1973 with grand 16th century Spanish-style architecture in honor of General Percival Major, who was thought to discover the Turks and Caicos Islands in 1593. There is also a statue of him displayed in the front yard of the school. The majority of the community on and around Percival Major Drive in Yankeetown are native to the Turks and Caicos Islands. In December 2019, Robert and Rachel Robertson, along with their daughter Louise Robertson, moved into a house on Percival Major Drive. In January 2020, Louise Robertson was enrolled at the Percival Major High School, where she would complete Form Year 11. Her parents were presented with the school's code of conduct, and they were very happy that Louise would be enrolled in such a good, reputable school that observed the Christian religious practices. Section 30 of the Percival Major High School Code of Conduct provides that, and I quote, "Girls here must be kept neat and flat and must be tied in a ponytail at all times. Dreadlocks will only be allowed for cultural or religious reasons," end quote. On the first day of school, however, Louise was informed that she must straighten her hair to look neater, as required by Section 30 of the school's Code of Conduct. Louise had a head full of rich, natural dreadlocks that she had been growing since she was a child. She took very good care to keep her dreadlocks clean and presentable. In an attempt to comply with Section 30 of the Code of Conduct, Louise started wearing her dreadlocks in a ponytail. However, she was asked to report to the principal's office, where she was reminded that Section 30 of the Code of Conduct provides that dreadlocks will not be allowed unless they are for religious reasons. On the 3rd of February 2020, the first quarterly parent-teacher conference was convened where teachers, the Parent-Teacher Association, PTA, the members of the school council, and the parents would meet. At the middle of the meeting, Dave Caicos, the chairperson of the school council, made a proposal on behalf of the community and the learners. The proposal was that the school's name be changed from Percival Major High School to Gertrude Ellis High School, the first principal of the school. There is no reason why the school should not follow the naming traditions of public institutions in the country. We should follow suit and begin to honor persons who have sacrificed to make this institution what it is today, said Dave. The principal immediately rejected this proposal because, and I quote, "The old name is a historical treasure and a heritage so intimate to the very being of many learners of the school," end quote. She then immediately adjourned the meeting and sent out a circular that the quarterly parent-teacher conferences were canceled until further notice. In the weeks that followed, Louise spent a lot of time in detention class for contravening Section 30 of the Code of Conduct with her dreadlocks. On 27th of April 2020, during a formal disciplinary hearing, the PTA made a decision to suspend Louise for continuous contravention of Section 30 of the Code of Conduct. Although the proper procedures were followed, Louise argued that she should be allowed to wear her natural hair the way she pleases. At the same hearing, the PTA formally rejected Dave Kakis's proposal to have the name of the school changed to Gertrude Ellis High School. Louise's neighbor, Mr. Griffin, a lawyer, decided to help Louise and took the PTA's decision on review to the High Court. After hearing about this, Dave Kakis, who is also Mr. Griffin's neighbor, asked to be joined in the proceedings. The Supreme Court held that since Louise was a Christian and not a Rastafarian, she is not entitled to wear dreadlocks to school in contravention of Section 30 of the School Code of Conduct. The Supreme Court further held that the immediate adjournment and cancellation of the meeting where renaming of the school to Gertrude Ellis High School was discussed was a violation of Dave Kakis's freedom of expression as envisaged by Section 13 of the Constitution. Louise and Dave applied for leave to appeal to the Court of Appeal, but leave was refused. Leave was granted, and the appeal was set down for hearing in April 2022 upon an application directly to the Court of Appeal. The appellants, Louise and Dave, must argue that, one, the application of Section 30 of the Code of Conduct violates the Constitution, and Louise must be allowed to wear her natural hair as she pleases. Number two, the refusal to entertain debate where the Percival Major High School will be renamed to Gertrude Ellis High School is in contravention of the Constitution, specifically Section 13 of the Turks and Caicos Islands Constitution. The respondent, the SGB of Percival Major High School, must argue that one, the application of Section 30 of the Code of Conduct does not violate the Constitution since Louise's dreadlocks are not for religious purposes. And number two, the refusal to entertain debate where the Percival Major High School would be renamed to Gertrude Ellis High School is in no contravention of the Constitution, specifically Section 13 of the Constitution. The matter has now been called before the Supreme Court for hearing on this, the 21st day of May 2020, before Justices Loban Jackson, Ariel Mizik QC, and Rhonda Lee Braithwaite Knowles QC.
All right. This Honorable Court of Appeal now resumes its sitting by order of the President of the Court of Appeal, the Honorable Mrs. Justice Loban Jackson. God save the Queen. Robinson, a minor, and Dave Capers against Principal Major High School and the Parent Teacher Association.
Good morning. We will now hear from Senior Counsel for the appellants in this matter.
May it so please the court, I'm Anaya Bovey, an appearance with Judah Rigby for the appellant. And to my right is Maya Dickinson and Chelsea Bean for the respondents. May I inquire if the court has received the appellant bundles?
We have, thank you.
If it so pleases the court, may I begin?
You may proceed.
Our first ground on appeal is that the trial court erred in law and fact when it decided that the school's application of Section 30 of the Code of Conduct, the suspension, and multiple detentions given to Louise did not violate her constitutional rights. The appellants submit that Louise's suspension was wrong in principle and should be reversed, as it did not take into account the fact that Section 30 of the Code of Conduct itself allowed for the wearing of dreadlocks for cultural reasons. The Percival Major High School stated in their code of conduct that dreadlocks would only be allowed for cultural or religious reasons. The principal made pronouncements which are against the code of conduct when she stated that dreadlocks were only allowed for religious reasons, when the section of the code of conduct clearly states that dreadlocks are allowed on the account of religious as well as cultural reasons. Now, my ladies, my lord, allow me to define the word culture.
Before you develop your argument, I have an interior question for you, and I'll probably have the same question for the respondents. Is the school, is that a public body? Is that a public school or a private school?
That information wasn't given in the fact, so we don't know if it was a public or private school.
Does it matter whether or not it was a public school or a private school for the purposes of your arguments?
No, my lord. May I continue?
Yes.
Allow me to define the word culture. Culture is the set of practices, beliefs, and objects that embody the most broadly shared meanings of a social system. It includes media objects, entertainment and leisure, fashion and trends, and linguistic conventions. In the Afro-Caribbean culture.
May I just interrupt you, Counsel? I noticed that in your bundle, you only have Percival Major High School listed as a respondent. Is that the only respondent in this matter?
Yes, my lady. May I continue?
Yes.
Dreadlocks have been a part of the African culture from as early as 500 BC. Louise had been growing her dreads naturally since she was a child, which obviously shows that there is a cultural connection to her hair. Louise's social origin, which would be growing up in the Caribbean around other Afro-Caribbean people, would mean she would be influenced by the people around her. Her identity and self-awareness is intertwined with the wearing of locks, and this must be held to a higher standard than that of just a simple hairstyle without meaning. It is clear that the wearing of locks is ingrained in the lifestyle of Louise and her family. And she was not in breach of Section 30. On the issue of the validity of the code, while the appellants recognize the school has the power to make rules to ensure discipline, those rules must be balanced with its duty to protect the rights of its students and the TCI obligations under the Conventions on the Right of a Child. The application of Section 30 of the code infringes Articles 3 and 28 of the Convention, which speak to the best interest of a child and the importance of access to education. My lady, my lord.
Can I ask you a question? Does the convention have independent force of its own?
No, my lord. May I continue?
Yes.
Consider the true harm that will result from a child having to choose between her culture, its expression, and her education. Giving a child an ultimatum which would determine her ability to attend school at such a critical age and time is unjustifiable and shows the school does not have its students' best interests at heart as they are obligated to by Article 3 of the United Nations Convention on the Right of the Child.
Miss Bovey, you said at a critical age and time. What was the age of the child in question?
She was 17 and she was a senior in her last year of high school.
Yes, you may continue.
Thank you. If the court will turn with me to tab T, page 2 of the appellant bundle,
Tab,
T.
yes.
Is the court with me?
Yes, you may continue.
Article 3 of the United Nations Conventions on the Right of a Child states, in all actions concerning children, whether undertaken by public or private social welfare institution, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration. The governing body and the rules of the Percival Major High School, along with its principal, are misguided by a code of conduct which does not have its students' best interests at heart. The school's treatment of Louise also violated her constitutional rights to freedom from discrimination and to freedom of expression. If I may turn the court's attention to tab S, page 2 of the appellant bundle.
Yes.
Section 13 of the Constitution states, except with his or her consent, no person shall be hindered in the enjoyment of his or her freedom of expression. And for the purposes of this section, the said freedom includes freedom to hold opinions without interference, freedom to receive and impart to the public generally or to any person or class of persons, ideas and information without interference, and freedom from interference with his or her correspondence or other means of communication.
What ideas do you say that she was expressing by wearing dreadlocks?
I think the appellant
The appellant.
believes that the idea which was trying to be expressed was her culture. Her dreads represented her culture. May I continue?
Yes, thank you.
The school's failure to recognize cultural expression as a valid reason for the wearing of locks contravened Louise's right to freedom of expression. The Constitution.
Where did she indicate that her dreadlocks was an expression of her culture?
It was not indicated by the facts, but because she had her dreadlocks before she could decide whether or not she wanted them, it shows that there's kind of a cultural background connected to it, because then her parents would have made that choice to lock her hair.
I have a follow-up question. Is it not the case that Louise is Christian? And so when you say it's a cultural expression, can you elaborate a little bit?
Cultural as far as being Afro-Caribbean, not on the basis of her religion.
Yes. Please continue.
Thank you.
Sorry, so you say it's her parents' decision, or is it her decision? Whose decision you say it was?
May I have a moment to?
Of course.
It was her parents' decision initially to lock her hair, but it was Louise's decision to keep the locks. May I continue?
Yes, please.
Thank you. The school's failure to recognize cultural expression as a valid reason for the wearing of locks contravened Louise's right to freedom of expression. The Constitution says expression, not speech. it carries a deeper meaning. It is the way that a person conveys his ideas and beliefs for them to be understood by those around them. The law has recognized that a person's choice of attire is tied to the expression of their gender identity, independence, and freedom. How individuals choose to dress and present themselves is therefore part of their right to freedom of expression. This choice is an expressive statement protected under the right to freedom of expression. The right to freedom of expression encompasses one's hairstyle, which is violated when the school, an agent of the state, imposed unreasonable and unjustifiable restrictions on dreadlocked hair in its school.
Ms. Bovee, let me just ask this question. Are you therefore saying that these freedoms that are guaranteed by the Constitution would trump the school's rules, which has the imperative of having the students attired neatly and in a uniformed manner? Are you saying that those rights are of a higher value or trumps the school's desire by their rules to have conformity and neatness and order within the schools?
May I have a minute to?
Yes.
Thank you. Okay, my lady. The matter is not of the child's right trumping the school's rules, but it is the application of the school's rules. And also, the school's rules should be in alignment with the supreme law, that supreme law being the Constitution. So the rules made by the school should be the same. It shouldn't hinder the freedom of any right that a child will have.
Thank you. You may continue.
Can I ask you one further question? You said the school was the agent of the state. If it was a private school, how does it become an agent of the state?
May I have a minute to confirm? My lord, whether public or private, the school would have still had the obligation to educate the child and be in alignment with the supreme law, the Constitution. May I continue?
So are you saying therefore that it was even if it is not an agent of the state, it is still a public body, a public authority. Is that what you're trying to convey?
Yes, yes, my lord. May I continue?
Yes.
Thank you. A code of conduct is also expected to be in accordance with the supreme law. That supreme law being the Constitution of the Turks and Caicos Islands. In this case, namely Section 16, the protection against discrimination. The school's failure to recognize Luisa's wearing of her hair in a ponytail as her complying with Section 30 of the Code of Conduct was discriminatory and contradicted Section 16(1), as it subjected her to a different standard, punished her, and required her to take more extreme steps to comply with the code than other students of different races and social origins with straight hair. In Section 16 of the Constitution, which is tab S, page 2, if the court will go with me there.
Yes.
Discriminatory is defined as affording different treatment to different persons, attributable wholly or mainly to their respective descriptions, such as by race, national or social origin, political or other opinion, color, religion, language, creed, association with a national minority, property, sex, sexual orientation, birth, or other status, whereby persons of one such description are subjected to disabilities or restrictions to which persons of another such description are not made subject or are accorded privileges or advantages which are not accorded to persons of another such description. In this case,
So which of those comparators you say applies in this case of the various comparators relating to forms of discrimination?
in this case, it would be social origin. Social origin would be the comparative. May I continue?
Was she the only person in the class with that particular origin?
Her social origin would have been what influenced her to have her dreadlocks. And as far as the facts given, nobody else had the same problems as Luis. So it shows that she was the only one with that social origin. May I continue?
Yes.
In this case, Luis was discriminated against because of her social origin.
So are you saying that Louise was the only child in the class that was Afro-Caribbean, as you informed us earlier? Is
No,
that not her social origin?
yes, my lady, but Luis wasn't the only Afro-Caribbean, but she was the only, as far as the facts, she was the only Afro-Caribbean with that certain cultural background, which would have caused her to have dreadlocks, those certain cultural beliefs. May I continue?
Yes, please.
Thank you, Milady. Social origin refers to elements that a person adopts from the surrounding culture. The school was evidently discriminatory in their action under terms of Section 16 of the Turks and Caicos Islands Constitution. The principal did not consider Luisa's cultural backgrounds, which she would have adopted from her surroundings, being an Afro-Caribbean girl, a satisfactory reason to allow Luis to go to school normally with no complaints, as everyone else with straight hair does. Prohibiting the wearing of dreadlocks, even when put into a ponytail, as is required of everybody else, because it was not flat enough, is indirect discrimination on the basis of ethnicity. The facts state that Luis always had her hair neat. It just wasn't flat enough for the principal. She tried to be compliant by changing her hairstyle to something more appropriate, rather than taking the extreme measures to cut or straighten her hair, which she had been growing for 17 years and was a part of her. The school seemed to suggest that the only way for her hair to be neat would be to straighten it. We submit that this suggestion is completely cruel to ask of a child. Poor Louise did everything she could to comply. Unfortunately, she was still eventually suspended. and enforcing this expectation, it is rather inhumane. The dreadlocks by now have formed a part of her identity. It is vicious to ask a child to remove something from their appearance that has strongly influenced the person that they have become. The appellants recognize the school right. The appellants recognize the right for the school and its PTA to create its own rules and guidelines per section 53, subsection 3 of the Education Ordinance to maintain discipline and decorum, but that must be balanced with its duty to protect the rights of its students. To add insult to injury, the Education Ordinance does not allow for a child, whether attending public or private schools, to be suspended due to his or her hair not being neat. If I may direct the court to tab R. Is the court with me?
Yes.
Section 34 of the Education Ordinance states, the principal of any public school may suspend from attendance any pupil who for gross misconduct may be considered injurious, dangerous to other pupils, or whose attendance at school is likely for any serious cause to have detrimental effect upon the other pupils. Arguably, the statute does not limit the reasons for suspension in a private school, but the reason for suspension must still uphold the charter requirements under Articles 3 and 28. How could it be said that Luisa's hair is a reasonable enough motive for her suspension when these laws say student really should be in school unless there's misconduct, which is considered injurious, dangerous, or detrimental? If those are the only bases on which the principal of the Percival Major High School could be rightfully suspending Luis, then it is evident that Luis was unjustifiably suspended. The Percival Major High and its code of conduct cannot be seen as constitutional when it has discriminated against their students due to their cultural practices and is not allowing them the freedom to express their culture and beliefs. The decision of the court below that the application was not unconstitutional should therefore be reversed. My lady, my lord, how can it be said that Luis's best interest was a primary consideration when the principal found that appearance of a child, whether tidy or not, is of higher importance than what is actually best for and most needed by the child, which is education? The actions taken by the principal and the PTA showed that what is important to the school is not the education of the child, but the appearance of the child. Luis was given detentions along with being suspended from school simply for her hairstyle, a hairstyle which is permitted by the school under certain circumstances. Those circumstances being a criteria which Luis was in line with, culture. This concludes our submission on the first round of appeal, unless there may be a further assistance to the court.
Thank you, Ms. Bovee. You may move on to your second round.
Thank you, my lady.
If it so pleases the court, before I begin, I noticed that the court had questions about the initial facts about the case. So I am questioning if the court would like me to rehearse the facts before I begin on the second ground of appeal.
No, not necessary. You may proceed to deal with ground two.
Thank you, milady. Milady, my lords, our second issue on appeal today is that the trial court erred in law and fact in holding that the cancellation of the meeting where the renaming of the school was discussed was not a violation of Mr. Kekis's right to freedom of expression. Milady, my lord, by the facts that have been provided, it is shown that the principal took deliberate steps not to allow Mr. Kekis the opportunity to express his beliefs about the naming of the school by deliberately canceling all sittings of the PTA meetings. The appellants submit that failure to allow Mr. Kekis to express his ideas in a forum that was designed for the input of its members is a violation of Mr. Kakis's right to freedom of expression as protected under Section 13, subsection 1 of the Turks and Caicos Islands Constitution. The PTA is supposed to be a collaborative group for promoting the interests of the school. It cannot be said that by canceling all meetings until further notice that the best interest of the school was being promoted. In doing this, the principal's actions failed to be in alignment with Section 53, subsection 2 of the Education Ordinance, which governs PTA associations. If I may refer the court to tab R.
So I want to ask you the same question asked to your colleague
Yes, my lady.
in respect of the second ground. Does it matter if this institution is a public or private institution?
No, my lady. We believe, as the appellants believe, that regardless of being a public or private institution, the education of the child and being in alignment with the supreme law of the Turks and Caicos Islands will always trump whether it's a private or a public school.
Thank you.
Thank you, my lady.
Can I follow up on that?
Yes, my lord.
Section 53 says that an association of teachers or parents and teachers may be constituted in connection with any public educational institution in accordance with regulations and so forth. So if this was a private school, it would not be constituted, the PTA would not be constituted under this section. It would be constituted independently of this section. And
May
so
I-
would this section apply to it?
May I ask where my lord is
53(1)
reading from?
of
53?
the Education Ordinance.
May you repeat the question, my lord?
The
I'm being
question
obliged.
is whether, if it was a private school,
Yes, my lord.
would the PTA of that private school have been constituted under section 53? Or independently of that?
May I have a moment to confer my colleague? Thank you, my lord. To answer that question, my lord, I would like to refer your attention to subsection 2 of section 53 of the Education Ordinance, which states the objects of such association shall include the promotion of the interests of the school by bringing parents, members of the community, pupils, and teachers into close cooperation.
Okay, but doesn't the reference to such association refers to the association referred to in section 53(1), i.e. the association of a public institution?
Yes, my lord, it does. But from the facts that we were given, based on the bundle that was provided, we can not, as the appellant, say whether or not the school was a public or a private body. But in subsection 2 of section 53, the suspension of the PTA meetings would therefore be a hindrance to any stakeholders that would be a part of the parent-teacher association.
Well, perhaps I can help you by asking this question. Irrespective of whether the school was a public school or a private school,
Yes, my lord.
would it be carrying out a public function by providing for the education of children?
No, my lord, it wouldn't be carrying out a public function if it was a private school.
Is not education a public, is not education something that is for the benefit of the public?
Yes, my lord, it is for the benefit of the public. Referring to the first question, namely section 53, subsection 1, which says an association of teachers or parents and teachers may be constituted in connection with any public educational institution in accordance with regulations which may be made under this ordinance, and the minister may encourage and assist the formation of such associations. Those guidelines would, I believe, not fall under a private school. There being that it's constituted in connection.
Could I ask you to read the line, the first line that is, the first two lines of paragraph 6 in your case?
The appellants submit that the failure to allow Mr.
No,
Kakers.
sorry, in the hypothetical case.
Oh, yes, my lady.
Facts,
Paragraph 6, you said, my lady?
paragraph 6, yes, first two lines.
First two lines. The proposal was that the school's name be changed from Percival Major High School to Gertrude Ellis High School, the first principal of the high school. Would you like me to continue, my lady?
Yes, please.
There is no reason why this school should not follow the naming traditions of public institutions in the country.
Does that give you any assistance?
Yes, it does, my lady. Much obliged. If I may refer back to the question asked by my lord, we do believe that from the hypothetical case, from the facts that were given, that Dave Kakers did put the school in the category of being a public institution. So therefore, section 53, subsection 1 and 2 would apply.
That's your submission.
Our submission is that the trial court erred in law, in fact, in holding that the cancellation of the meetings where the renaming of the school was discussed was not a violation of Mr. Kakers' right to freedom of expression. That would be our submission, my lady.
While you're at the hypothetical case, can I ask you this question?
Yes, my lord.
It says in paragraph 6.
Of the hypothetical case, my lord?
Yes,
Yes, my lord.
the last two sentences.
Yes,
It
my
says
lord.
the principal immediately rejected this proposal
Yes, my lord.
because the old name is a historical treasure and a heritage so intimate to the very being of many learners of the school. She then immediately adjourned the meeting and sent out a circular that the quarterly parent-teacher conferences were canceled until further notice. So that suggests that she actually made a decision
I have a moment to
on the proposal that was put by.
So the question posed, my lord, is
By Mr. Kakers, Dave Kakers,
the question posed, my lord, is whether the principal made a
made
decision
a
or not.
decision on the proposal.
May I have a moment to confer with my senior counsel? Thank you, my lord. My lord, for answering the question, it can be said, yes, indeed, that the principal did make a decision. That is the reason why we are here today, because the decision she made was not in alignment with what a PTA is supposed to be. If I may refer the court once again to section if I may refer the court to the fact that PTA is supposed to be a democratic institution. The PTA is supposed to be an institution where each member Each stakeholder is supposed to be able to be allowed the opportunity to share their views and reasons why. From the facts given, nobody else was able to express their views on what they thought the naming or the renaming of the school should have been, due to the fact that the principal immediately canceled the meetings after she made her comment until further notice, my lord.
So wouldn't it follow from that then that Mr. Percival had in fact expressed his views, but the principal failed to allow a debate following the expression of his views, and therefore her decision was arrived at unfairly because she never allowed others to express a view. So isn't it, wouldn't it have been open to you or to your client, Mr. Percival, to challenge that decision on the ground that it was arrived at unfairly?
We know not if that, we know not.
Sorry, Caicos, yes.
We know not whether the information that was given. Yes, my lord, we did. But as the appellants, we believe that even though it did violate that and the decision was made unfairly, the greater violation was of Mr. Caicos's right to freedom of expression.
Okay.
That was the greater right that was violated, my lord.
If the court was to agree with you,
Yes, my lord.
Remedy would you get? What would be the effect of the remedy?
May I have a moment to confirm my colleague, my lord? Thank you. My lord, before I answer, I humbly ask that you repeat the question,
Well,
please.
if the court was to agree with you and say that the decision was arrived at wrongly because it violated Mr. Caicos's constitutional right?
Yes, my lord.
What would be your practical remedy?
As the appellants, we believe that our practical remedy would be to allow Mr. Caicos to exercise his constitutionally protected right to freedom of expression and let his voice be heard, which is allowed in a democratic society.
So the question of the renaming of the school would have to go back to the PTA for reconsideration. Is that?
Of the renaming of the school?
Renaming of the school, yes.
Yes, my lord.
Yes. And would that not be the same result if you had made an application for judicial review and had the court granted your application for judicial review?
Humbly ask that you rephrase the question, my lord.
Yes. If instead of bringing the constitutional motion, you had applied for and obtained leave for judicial review, and the court having reviewed the decision of the principal,
Yes, my lord.
would not the court then, would it not be the case then that the question of whether the school ought to be renamed go back to the PTA for reconsideration? So the result would be the same either way, whether it was judicial review or whether it was constitutional relief.
As the appellants, we don't believe that it would be the same way because from the facts that were provided, initially, Mr. Keikos was not given he did not fully exercise his right to freedom of expression due to the fact that the meetings were canceled completely after without being put to a vote, therefore not making it aligned with a democratic society. So after further review by the court and a decision being made, we do not believe that the result would have been the same, but that Mr. Keikos was allowed, or that would be that Mr. Keikos would be allowed to express his ideas, views, and beliefs in a safe manner, which is justified by democratic society.
Thank you.
Yes, my lord.
What is the authority of the PTA? Where do you see the authority of the PTA to rename the school?
If I may refer the court to, I believe this would be tab R of the appellant's bundle.
Mhm.
Tab R, page 3, section 53.
Yes.
Subsection 3 states that each such association subject to this ordinance and any regulations make rules for the regulation and control of its business.
Of the business of the PTA.
The appellants believe that the PTA being the governing body of the school, the PTA would not only make rules for the regulation and control of its business, but being the governing body, the school's business as well.
Is your argument helped by subsection 2, which says the objects of each such association shall include the promotion of the interests of the school?
Yes, my lord, our argument is very much helped by subsection 2, which, to refer to Milady's question, the PTA the PTA is required to include the promotion of the interests of the school. So not only does the PTA make rules for the regulation of control of the PTA and its business and the school, but also the promotion of the best interests of the school. And as presented by Mr. Keikos, he did believe, if I may refer the court to the hypothetical case, namely paragraph 6. The last sentence of paragraph 6, which says, there's no reason why this school should not follow the naming traditions of public institutions in the country. We should follow suit and begin to honor persons who have sacrificed to make this institution what it is today. So the appellants do believe that Mr. Keikos, by putting this matter up to the PTA, was indeed in alignment with helping to promote the best interests of the school.
Before you close, Mr. Rigby, you referred many times to the PTA, that the PTA is supposed to be a democratic body. On what are you basing that argument on? If I would
Sorry, Milady, may you
repeat the question.
Yes, thank
You
Milady.
said several times that the PTA is supposed to be democratic. What are you basing that assertion on?
May I have a moment to confirm, my
Yes.
colleague? Thank you, Milady.
Yes.
Milady, if I may refer the court's attention once again to the appellant's bundle, namely tab S.
Yes.
Page 2. Is the court with me?
Page 2.
What section?
Section 13,
Yes.
the protection of freedom of expression. If I may refer the court to subsection 2 of section 13, which states nothing in any law or done under its authority shall be held to contravene this section to the extent that it is reasonably justified in a democratic society.
And that is what you're basing your assertion on, that the PTA ought to have proceeded in a democratic manner.
The PTA, and as my Lord has helped me to find based on our facts, or would be considered to be a public school, which make them fall suit to the Constitution, the supreme law being the Turks and Caicos Islands Constitution, meaning that when Mr. Caicos's right to freedom of expression was violated by not letting his full opinion be heard and his voice silenced by the cancellation of the PTA, they did not fall in any of the categories that subsection 2 named that were reasonably justified in a democratic society.
Yes. Thank you, Mr. Rigby. Does that conclude your submissions?
No, milady.
Yes, please
May I
continue.
continue? Thank you, milady.
Despite the many interruptions, Mr. Rigby, we are almost out of time for your submissions. So if you could give us the most important points of what you have left.
Humbly beseech the court to confer with my colleague for a
Yes.
moment. Thank you, milady. May I continue, milady?
Please do.
Thank you, milady.
If you could summarize
Yes,
your
milady.
argument under the ground 2.
Ladies, my lord, Mr. Caicos tried to exercise that right, and the response of the principal was deliberate interference. She immediately rejected the proposal and adjourned the meeting unilaterally, thereby preventing Dave Caicos and any other parent or teacher from receiving, as well as imparting ideas and information, violating Dave's constitutional right to freedom of expression. Ladies, my lord, most importantly, when considering the limitation in subsection 2, it is only possible to the extent that it is reasonably justified in a democratic society. A democratic society is based on representing individual rights and allowing each person to express themselves and their ideas, and for decisions to be made through an open voting process. The principal's cancellation is the opposite of true democracy, my lady and lord. And taking the vote at her own convenience is the opposite of true democracy, being that there was no opportunity from anyone else to express themselves through the said open voting process. We beseech this honorable court to find favor with the submissions of the appellant and to overturn the ruling of the court below. From the issues outlined in this appeal, it is without a doubt that Dave Caicos and Louise's right were both violated. Louise Robinson was treated with disdain because her hair was not straight enough, and her right to express her culture was disregarded by a school administration who did not even bother to have regard for their own rules. The way Louise was treated was born of discrimination on the basis of her social origin. As neatly groomed as she was, she could never be good enough for an administration which did not respect, as my senior counsel mentioned, her Afro-Caribbean culture. Let this case, my ladies, my lord, be a lesson to all those that attack our democratic institutions, our PTAs, and all those groups we have joined to make our voices heard. To remind those who would enforce their will on others that our Constitution protects our freedom of expression, and disregarding it will not be tolerated. Unless I can be of further assistance to the court, my ladies, my lord, that is the extent of my submission.
Thank you very much, Mr. Rigby. We will now hear from senior counsel for the respondents.
I am Ireland, and I'm here in this appeal as senior counsel on behalf of the respondent. With me is my learned legal counsel, Chelsea Peter. Unless your lordship wishes otherwise, I'll proceed with the opening and presenting of the respondent's case before the court.
Yes, you may proceed.
I refer your lordship to section 13 of the Turks and Caicos Islands Constitution, which can be found at tab 3 of the respondent's bundle. In Article 13 of the United Nations Convention on the Rights of a Child, which can be found at tab 6 of the respondent's bundle, which establishes the right to freedom of expression in similar terms as set out in section 13 of the Constitution. The respondents will also refer to section 53 of the Education Ordinance, which can be found at tab 8 of the respondent's bundle. Each section will be considered in turn. The first appellant failed to prove that the wearing of her dreadlocks is captured by section 13 of the Constitution. My lords, in the case before you this morning, you are called upon to analyze the school's code of conduct, and in particular, section 30 thereof, and determine whether it is unconstitutional. Before delving into arguments about the constitutionality of section 30, it may be useful to understand the origins of the school's code and to bring into focus the importance of the rules stipulated therein. I refer your lordship to section 53 of the Education Ordinance, which can be found at tab 8 of the respondent's bundle. And in particular, section 53, subsection 2 and 3 thereof. This section essentially permits educational institutions to form governing bodies, much like the PTA. This is to promote the interests of the school and to make rules and regulations to control its business. The importance of rules in the education context cannot be undermined. It promotes an important sense of discipline in the students enrolled therein and nurtures and prepares them to function adequately and effectively in the real world. The school's code of conduct had been promulgated by the PTA and in consultation with the parents, members of the community, pupils, and teachers, and accordingly represented the combined wisdom of all who participated in its construction and should therefore be respected. It is the practice of the school that exemptions based on religious considerations are made from provisions of the code. Section 30 provides that girls' hair must be kept neat and flat and must be tied up into a ponytail at all times. Dreadlocks will only be allowed for religious or cultural reasons.
Can I ask you a question? So in relation to section 30 of the code, the first part talk about hair being neat and tidy. Was it not sufficient to stop there? Why was it necessary to go on to say, to specifically identify dreadlocks? Is there something untidy about dreadlocks?
My lord, can you repeat the question?
Okay. You were talking about the code, section 30 of the code of conduct of the school. And the first part of it talks about hair being neat and tidy. And then it goes on to specifically address dreadlocks. So my question is, why is it necessary to address dreadlocks? Is that because there's an indication that dreadlocks is itself untidy?
My lord, the respondents submit that dreadlocks were not addressed because it was related to the negative connotation of being untidy or messy, but rather it was included because there are oftentimes persons who have dreadlocks for religious or cultural reasons. And to include them in the construction of Section 30, they allowed for an exemption of dreadlocks to be worn.
Go on.
My lord, may I continue?
Yes, of course.
My lords, it is the respondent's submission that the code is lawful in that it establishes realistic boundaries and provides for possible exemptions on the basis of religion and cultural beliefs, thereby fostering a spirit of reasonable accommodation in the school's context and to avoid such acrimonious disputes like the present. This case can also be applied in terms of Section 13, subsection 2 of the Constitution.
Before you move on, the court below dismissed the challenge on the ground that the appellant was a Christian and therefore the religious exemption did not apply. What about the cultural exemption?
My lord, it was the duty of the first appellant and her parents to give evidence to this honorable court that her dreadlocks were worn in order to manifest a specific cultural or religious belief. Because there was no evidence submitted to this court, the appellant cannot argue that her dreadlocks were worn for cultural reasons. My lord, may I continue?
Yes, continue.
This case can also be applied.
Well, can I just ask you that one question? Had she argued and or provided evidence as to that, would the outcome, should the outcome have been different?
My lord, if the first appellant had submitted evidence that her dreadlocks were worn for cultural reasons, because the Section 30 stated an exemption for cultural or religious reasons, the first appellant would not have faced any disciplinary actions because she would have fallen under the exemptions of Section 30.
So had that been the case, then there would have been no challenge from the school. Are you suggesting that the school would not have disciplined her?
Yes, my lord, that is my submission. As established previously.
But your friends say that her cultural, the evidence of her cultural reasons is because she's Afro-Caribbean.
Yes, my lady, but nowhere in the facts stated of Louise's race or social origin or any cultural reasons for her to wear her dreadlocks. My lady, my lord, may I continue?
Yes.
As established previously, Section 13 speaks on freedom of expression. However, subsection 2 encapsulates the derogations to this right. Some derogations permitted in subsection 2 are if it has a negative effect on the public. For example, public order. The school has the right to formulate policies to maintain discipline and decorum in order to promote an effective and conducive learning environment for its students.
If I could just interrupt you there for 1 minute, Ms. Dickinson. Are you saying in effect that the wearing of dreadlocks is disruptive to discipline and public order?
My lady, our submission is that the wearing of dreadlocks, if it does not fall under the exemption of Section 30, could cause a disruption in the school's running, because other students of the Percival Major High School may see it fit for them to go against the rules of the school as well. This is not something the school wants. The school wants to promote order and uniformity. So by allowing the appellant to not to conform to this rule, it would promote a sense of inequality and be unfair to the other learners.
But you're relying on public order as being the justification in the public interest in a reasonably democratic society. So what is public order in subsection 2 referring to? It is referring to, isn't it not referring to the kind of activity that might give rise to disorderly conduct or in the school itself? For example, like when you refer to public order, it connotes sort of either criminal activity or public disturbance at a community level, where people's lives or property might be in danger. So why would public order be applicable in a case like this?
My lord, public order can be defined as anything that disrupts the smooth running of the public. That means that if the first appellant had been exempted from having to conform to Section 30, and other students in the school had decided that they do not want to follow the rules of the school anymore, they can affect the running of the school, the discipline. This will cause chaos, in other words.
Continue.
That right must be balanced against the school's corresponding duty to protect the fundamental rights and freedoms of their students. The respondents do not challenge that the fundamental right encapsulated in Section 13 of the Constitution is a right that must be protected. This right includes the right of minors, which is reflected in Article 13 of the United Nations Convention on the Rights of a Child. My lords, Section 13 of the Turks and Caicos Islands Constitution provides for all persons to enjoy their freedom of expression, and this right cannot be hindered without their consent. Freedom of expression means that everyone is free to hold their own opinions and ideas. With respect, the respondents submit that the appellants erred in its submissions that this included the wearing of a particular hairstyle, unless it is to show that the wearing of that hairstyle is to express one's opinions or ideas. My lords, the first appellant submits that she wore her dreadlocks for cultural reasons. However, the first appellant did not provide any such evidence to satisfy this honorable court of her position. My lords, the burden is on the first appellant to provide evidence to substantiate her contention that her dreadlocks are indeed connected to her cultural identity. The code specifically stated that only for religious or cultural reasons were dreadlocks to be exempted. As there is no evidence, the first appellant must conform to the same rules as the rest of the student body. The first named appellant had not produced any evidence to show that the wearing of her hairstyle, in particular dreadlocks, was peculiar and particularly significant manifestation of her religious or cultural beliefs, or central to any particular religious or cultural practice. The evidence succinctly states that the parents of the first appellant observe the Christian religious practices. Further, my lords, the tenor of the case advanced on behalf of the first appellant is not one in which she is defending the abridging of religious or cultural freedoms. In fact, my lords, based on her statement that she should be allowed to wear her natural hair the way she pleases, it is clear beyond dispute that the first name appellant's wearing of dreadlocks was not linked to any particular religious or cultural belief, but rather linked merely to her desire to promote her own mode of self-expression. While there is no doubt that self-expression is an important right and should not be limited or hindered without justification, the respondents submit that the right to self-expression is not absolute and must be considered in light of its impact on the school and its learning objectives. Allowing this exemption for the first named appellant would impact negatively on the discipline in schools, and as a result, on the quality of education they provide, and impose an undue and unreasonable burden on the school. The first name appellant's interest in wearing her natural hair the way she pleases could never outweigh the general importance of ensuring discipline in schools.
So are you saying the right to expression of your own individuality is not a protected right? Is that the fact of your submission?
No, my lord. The fact that we submitted is that the right to expression of a particular idea that is not even one of your own.
Was it not her own? Was she not expressing her own individuality?
My lord, may I have a minute to confer with counsel?
Yes,
Thank you. My lord, it is the submission of the respondent that the right to freedom of expression is not absolute. And as stated previously, the wearing of her dreadlocks may have imposed on the rights and freedoms of others or affected the public order of the school. My lord, if that is enough, may I continue?
of course.
The concept of self-expression is fluid and will vary based on individual characteristics. The first appellant seemed to be advocating for a wide, unfettered acceptance of self-expression for individual students. That would just make a mockery out of the school rules and would be an unreasonable burden for the school to bear.
What other acceptance would you say? Do you say she was? She's angling for. The only exception that arises in this case is that of being dreadlocks.
My lord, may you repeat the question?
This case is about dreadlocks and not about anything else, is it not?
My lord, may you rephrase?
We're here concerned with whether the exception
Yes, sir.
or the prohibition on dreadlocks is constitutionally valid.
My lords, by exception, we mean the exception to her dreadlocks because of religious or cultural reasons. There was no other reason for the school to make an exception for the first appellant. My lord, may I continue?
Yes.
To condone the concept that students and their parents can simply thrust their own individual ideas of self-expression and come adorned in whatever they deem acceptable in defiance of the established school rules and regulations is to open the floodgates for chaos and anarchy in schools. To make an exception in favor of the first appellant would be setting the stage for a parade of horribles, so that fashionable dreadlocks, body piercings, tattoos, and loincloths would have to be accepted as a means of self-expression and a permitted exception to the school's code? My lords,
I'm sorry to interrupt you, Ms. Dickinson.
yes, my lady.
You're saying in effect that by allowing Louise to wear dreadlocks to school, that would open a floodgate to a number of other transgressions of the school rules not contemplated by the two exceptions.
Yes, my lady.
I see. Please continue.
Thank you. My lords, making an exception for the first appellant not to conform to section 30 of the school's code of conduct would be unfair to the other learners. This could give rise to the perception of inequality and could infringe on the rights of other learners. To allow such deviant behavior could plant a seed of defiance in the minds of other learners of the Percival Major High School and could promote a feeling of truancy within the institution. My lords, the fact that everyone has the right to freedom of expression is not in dispute. And it is also not disputed that students do not shed their constitutional rights to freedom of expression at the schoolhouse gate.
Just to be very clear, when you say deviant behavior, what are you referring to specifically?
When I refer, my lady, when I refer to deviant behavior, I'm referring to continuous defiance of the school's rules. In particular, section 30.
Yes.
My lady, may I continue?
Yes.
The respondents contend that in order for there to be an infringement, the first appellant must show that the wearing of her dreadlocks, she was expressing a particular idea or belief, and that the prohibition of that hairstyle is suppressing the expression of that belief or idea. There was not an iota of evidence presented in these proceedings to establish that fact. In the absence of any evidence to show otherwise, the application of section 30 of the code cannot be said to have violated the appellant's rights to freedom of expression. My lords, it is therefore the respondent's submission that this ground of appeal must be rejected as being manifestly ill-founded and must therefore fail. My lords, unless this honorable court wishes otherwise, these are the submissions on the first ground on behalf of the respondent. Junior counsel, Ms. Chelsea Bean, will now submit on the second grounds on behalf of the respondent.
Just before you go, Ms. Dickinson, your friends say that section 34 in their bundle at tab R is what is the provision that allows for suspension. And in that section, the principal of any public school may suspend, assuming your friends are correct in their submission that this is a public school. But in the facts that we have been given, the PTA made the decision to suspend. Was the suspension in keeping with the ordinance?
My lady, because the PTA refers to the community, pupils, teachers, parents alike, including the principal, the suspension was in fact right.
So you say the principal made the decision as part of the PTA?
Yes, my lady. But that is
Thank you.
not all.
Thank you.
Thank you.
Thank you, Ms. Dickinson. We'll now hear from junior counsel for the respondents.
Thank you, my lady.
May I proceed?
Yes, please proceed.
My lords,
I will now submit on the ground that the refusal to entertain a debate with the Percival Major High School would be renamed to the Gertrude Ellis High School was not in contravention of the Turks and Caicos Islands Constitution. I would refer your lordship to section 13 of the Turks and Caicos Islands Constitution at tab 3 of the respondent's bundle, and section 53 of the Education Ordinance at tab 6 of the respondent's bundle. My lords, as already established by senior counsel, section 13 of the Constitution provides for the right to an individual's freedom of expression. It is the submission of the respondents that the second named appellant made his proposal in the middle of the first quarterly PTA conference. My lords, there is no evidence that the second named appellant made representations that he wanted to state anything further after he made his proposal, and that he was barred from doing so. The evidence shows that the second named appellant had his opportunity to speak without interference or hindrance of any outside party, and that the proposal was made to the desired audience. Therefore, in the absence of any evidence to the contrary, this honorable court is constrained to find that there is no breach of the second appellant's freedom to express himself.
Can I ask you this? Had there been a debate, is it not reasonable to assume that he might have had something else to say as a result of the ongoing debate?
My lord, may I confer with senior counsel? My lord, the facts do not show that the second named appellant had anything further to say. May I proceed?
Yes.
Additionally, my lords, the principal as the chair of the PTA conference is responsible for the structure, efficiency, and smooth running of the conference. And this includes ensuring that there is sufficient time allocated for each item on the agenda. I refer your lordship to section 53 of the Education Ordinance at tab 6 of the respondent's bundle, which outlines the rules of the PTA.
What do you say is the effect of the failure for the principal to entertain a debate? How does that affect the validity of her decision?
Can you rephrase that question, my lord?
Yes. The principal did not allow or encourage or entertain any debate. How does the failure of her to do that, how does that affect the validity of the decision she made to reject the proposal?
May I confer with senior counsel? My lord, the decision to reject the proposal did not affect the validity of the proposal made by the second named appellant, because the PTA further after the adjournment of the meeting came together as an executive to decide the decision on the proposal and presented it to the second named appellant that they formally rejected it at a further date.
Where's the evidence of that?
I refer the court to paragraph 7 of the hypothetical case. The last sentence, at the same hearing, the PTA formally rejected Dave Case's proposal to have the name of the school changed to the Gertrude Ellis High School. So in fact, they did make a decision. May I proceed?
Yes, go on.
Section 53, subsection 4 provides for the PTA and the school council to work together in the maintenance of the school's common interests. As the chair of the school council, the second named appellant ought to have known of the rules that govern the PTA conference. My lords, the proposal to rename the school is one of great importance to both the community and learners, and one which required extensive consultation. It is the respondent's submission that there were options available to the second named appellant to bring this important matter to the respondent's attention in advance of the conference, to provide the respondents with an opportunity to consider whether there was a need to hold a separate meeting or whether this matter could have been added to the agenda. Failing to write, call, or request a meeting with the principal, the second named appellant could have also waited until he had an opportunity on the agenda to raise the proposal under any other business. My lords, none of these structured options were explored by the second named appellant. Instead, the evidence shows that he made his proposal in the middle of the meeting, having no regard to the chair's need to maintain structure and order the proceedings.
Did the principal suggest to him that he should hold off on his proposal and make it at the end of the meeting under any other business? Was that suggestion ever put to him?
My lord, the facts do not state this, but the nature of the proposal which was made by the second named appellant would have attracted comments from the floor and other members of the community who would have wanted to engage in further discussion of the proposal. But if the principal had entertained that proposal and the debate on that proposal, it would have sent the meeting into a tailspin, which would have further knocked all the items which were already on the agenda into not being discussed.
Was any attempt made to put the proposal for discussion at another meeting before it was rejected?
My lord, may I confer with senior counsel? My lord, specifically looking at the position which the second appellant holds as the chairperson of the school council, the second appellant ought to have known the procedures which are followed when setting a meeting such as the PTA. So in fact, he would have known that in this case, he would have had to send something in beforehand to the PTA so that it could be added to the agenda. May I proceed?
You might.
Instead, the evidence shows that he made his proposal in the middle of the meeting, having no regard to the need to maintain structure and order of the proceedings. It is the respondent's submission that the time wherein the second appellant made his proposal violated and disrupted the flow of the meeting. Such an outburst made it difficult for the principal as the chair to maintain order and continue with the meeting. Further, my lords, the renaming of the school is a matter of public interest. Since it was not an item for discussion on the agenda, the respondents submit that the principal was concerned that things could have become chaotic. Therefore, the decision was justified.
Might I just ask you, Ms. Bean, was the immediate rejection of the proposal by the principal, did that affect the fairness of the decision ultimately? The immediate rejection in the meeting, did that affect the fairness of the decision?
My lady, the immediate rejection of the proposal in the meeting did not affect the outcome of the proposal. As in fact, the principal, as a part of the PTA, made that decision to reject it, which she further went on later on to state that she would call a meeting with the PTA and they discussed it themselves and then formally rejected the second name appellant's proposal.
I see.
Who was present at this subsequent meeting? Was Mr.
Mr. Kakis was present along with the first name appellant, as stated by paragraph 7 of the facts.
That is, my reading of it doesn't indicate to me that this was a separate meeting.
It says,
Okay.
may I proceed?
Yeah, go ahead.
Alternatively, my lords, the respondents rely on section 13, subsection 2 of the Constitution, which permits an authority to derogate from this right to the extent that its actions are reasonably justifiable in a democratic society. Section 13, subsection 2 of the Constitution provides for the limitations which include public safety, public order, protecting the rights, reputation, and freedom of others, amongst other circumstances. It is the respondent's submission that the principal's quick response was done in the best interest of public order and to protect the interests and reputation of others. The adjournment of the meeting prevented what could have become a heated, uncontrollable debate. The adjournment of the meeting was not in an effort to silence the second name appellant from expressing his point of view, but rather in an effort to preserve order and to prevent the meeting from spiraling out of control, as that was the duty and responsibility of the principal as the chairperson of the meeting. Further, my lords, this was the first time the principal and the PTA heard of the proposal. It is the respondent's submission that the adjournment also afforded the PTA and its members with an opportunity to consider the proposal. My lords, the respondents submit that the PTA followed proper procedure in ensuring that the views of the second appellant were considered in its entirety. My lords, providing all the evidence stated previously, this ground must be dismissed. My lords, to allow this appeal to succeed would set a precedent where rules of meetings can be disregarded and open the floodgates for expressions to be considered without due regard to the rights and freedoms of others. It is the respondent's submission that this honorable court must confirm the decision of the court below as it relates to its findings that the refusal to entertain a debate about the renaming of the Percival Major High School to the Gertrude Ellis High School is not unconstitutional and does not infringe on the second name appellant's right to freedom of expression as guaranteed by Section 13 of the Turks and Caicos Islands Constitution. Therefore, this ground of appeal should be dismissed with cause to the respondents. This honorable court should therefore dismiss this entire appeal on both grounds advanced by the appellants with cause to the respondents. Unless I could be of any further assistance to your lordship, this concludes the submissions on behalf of the respondents.
Just one moment, please.
Ms. Bean, I just have one question for you. It's the same question that I raised with your learned friends. Did the PTA have the authority to rename the school?
My lady, as referred to, as referring to Section 53 of the Education Ordinance, which can be found at tab 6 of the respondent's bundle. Subsection 3, each such association shall subject to this ordinance and any regulations, make rules and regulations and control its business. So the renaming of the school would be in fact its business.
The business of the PTA?
Yes, ma'am. Yes, my
So
lady.
you say the business of the PTA is the business of the school?
Yes, my lady.
Well, just to follow up from the last question, the reference to business, is that not a reference to the procedure of the PTA?
Can you
Rather than-
rephrase that question, my lord?
Is the reference to business of the PTA, is that not a reference to the procedure as it relates to matters under consideration at the PTA, rather than the business of the school, the naming of the school.
My lord, may I confer with senior counsel? My lord, the decision which was made on the renaming of the school is in fact the business of the school. It's in fact the business of the PTA. As the PTA comprises of the students, the teachers, the members of the community, all who have interest in that specific school. So in fact, the renaming was its business. May I be of any further assistance to your worship? Thank you.
Thank you very much, Ms. Bean. We will now retire very briefly to consider the submissions and return with the results.
All right. The final subject appeal is now adjourned while their votes deliberate. There was no preference for subject appeal.
Yes. Sir.
All right. This honorable court of appeal now receives its sitting by order of the president of the court of appeal. God save the king.
May I firstly congratulate all the advocates who presented in a very spirited and well-prepared manner this morning into this afternoon. It was very close. However, the decision of the court is as follows. With respect to the arguments which were presented, the respondents are successful and the decision of the court below is upheld. Costs are awarded to the respondents to be agreed or taxed. In relation to the team which won the moot here this afternoon, the respondents are the successful team. And in relation to the most successful or best advocate of the day, that goes to senior counsel for the respondents, Ms. Dickinson. Congratulations to you all. Court will now be adjourned.
All right. This honorable court of appeal is now adjourned by order of the president of the court of appeal. God save the king.
Ask them to join us. Okay, so thank you all for joining us in the finals of the National Moot Court Competition. And we are inviting everyone to meet us downstairs in the tents for a cocktail reception and award ceremony.
It was all day. Yes, I'm sure, I'm sure. How are you? How are you? Good. How are you? Yes, I'm glad.
So you would take that in the background? Yeah. But you need to take anything about that. You know, I need to say.
Yes, we're still live streaming, yeah. We need to keep it on for the awards ceremony.
Okay. What's that?
You need to stand as well. And we're using this tripod.
Yes.
Thank you. Please speak the words.
Test. Too loud. Too loud. Yes. 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 Test. Oh, you put the volume down? Test. Okay. It should be fine now.
Thank you. So can you keep that one for us? Or can you just can you keep that one for us? The GPP, Ms. Otanye. We have one more. Miss Fania Felipe. Her mentor should be here. Miss Fania? Oh, she's here. Can you present this? That's it. That's it. That's it. Angelina. Okay, we are calling for the Minister of Education to present this award. It is to Miss Angelina Lanton from the British West Indies Collegiate. She is awarded with an internship opportunity at the Labor Tribunal. Oh, wait. We have another one for the Labor Tribunal. Miss Kiana Hamilton. I think she's here. Yes. Miss Kiana Winter was awarded with an internship from Tuam Marcelin Wolf. I don't think Miss Winter is here, and there's also not a representative from Tuam Marcelin Wolf, so we will arrange to have this sent to her school. Okay, we are calling Miss Sabrina Green from the Human Rights Commission and Mr. Thias Burgess from the British West Indies Collegiate. Thias. So Thais is awarded with an internship from the Human Rights Commission. We will like to call Ms. Sheena from F Chambers to present this award. To Ms. Erlene Juristin. So Ms. Erlene was awarded an internship at F Chambers. Mr. Francois Guy was a participant in the competition and he is awarded a work placement at Graham Thompson. I don't see anyone from Graham Thompson, nor do I see Francois, so we will arrange to have this sent to his school. Emanuela Tharabin. So Emanuela is awarded with an internship at Bayport Smith. Mr. Robert Brooks is awarded a work placement at Michigan Stambra. We would like to call Miss Sarah Knight. Okay, we would now like to move on to our participants in today's semi-final.
We do have self-paced too, so we're sending it directly to the school.
We also have the certificates for the South Caicos students and their internships, but since they couldn't make it today, we will be sending it directly to their school. Okay. We'd like to call Miss Anaya Bovey. The Attorney General. Miss Anaya Bovey is awarded a work placement at the AJ Chambers. We'd also like to call Mr. Judah Rigby. He is also awarded with a work placement at the AG Chambers. We would now like to call Ms. Chelsea Bean and Ms. Maya Dickinson. Justice Logan Jackson to present these awards. The winners of today's finals are presented with a work shadowing opportunity with the judiciary. Okay, we would like to now call Mr. Ariel Mizik to present the awards for the best advocate of the competition series. So we would like to start with the nationals round. Ms. Chelsea Bean was the best advocate for the nationals round of the competition. Chelsea was also the best advocate, one of the best advocates at the semifinals round. So we're calling Chelsea back. And we would also like to call Mr. Judah Rigby. He was also one of the best advocates during the semifinals round. And we would now like to call Ms. Maya Dickinson to receive the Ariel Mizik Rising Star Award, which is presented for outstanding demonstration of advocacy skills during the 2022 competition. Thank you. We would like to call Ms. Sarah Knight to make these presentations on behalf of the bar to the runner-ups. That would be the Precious Treasures International team, Judah Rigby and Anaya Bowley. Thank you. Now I'd like to call Justice Addy. to present the award to the 2022 National Champions, which is sponsored by the TCR Bar Council in partnership with the TCI Judiciary in support with the Ministry of Education. So we're calling Chelsea and Maya. Chelsea, here's another one. So, Maya and Chelsea, we're asking you to stay. And we also have the Champion Shield, which is presented by the TCI Judiciary and the Bar Council. This will be a floating shield that is rotated to the winners every year. So we are called to the school every year. So we are calling Ms. Tremaine Swan to present this on behalf of the Bar Council and Justice Loban Jackson on behalf of the Judiciary. We would also like to announce that the best advocate of the recipient of the Aerial Music QC Rising Star Award, she also has a $500 Southwest gift voucher. So we will take your details, Maya, so that it can be entered into the system. I'll give it to you. I'll get it from you. Okay, so we are calling the Minister of Education to present the Minister's Cup to the winning school. This is also a floating trophy that will rotate to schools every year. So Maya and Chelsea. We would like to call Justice Loban Jackson to accept this reward for the TCI Judiciary and the Chief Justice for their extraordinary commitment as a launch partner for the 2022 National Moot Court. Thank you from the TCI Bar Association. We would now like to call the Minister of Education, Honorable Rachel Taylor, to accept an award from the TCR Bar Council and TCI Judiciary for extraordinary commitment and support to the launch of the 2020 Nationals. Okay, so we would now like to call up the mentors who are here. We would not have been able to complete this competition without the mentors. They worked closely with the students from October 2021 until today's date, just making sure that the students were ready for the competition from the nationals round to the finals. So I would like to call Mr. Andrew Mitchell, QC.
Thank you very much.
Thank you. We'd like to call Ms. Sheena Mayer. Ms. Cheyenne Gardner. And Ms. Cheyenne Gardner was the mentor, one of the mentors to the H.J. Robinson High School. That's okay, here we go. We would like to call Ms. Clamar Hippolyte from the AG Chambers, who was also one of the mentors for the winning school. I'd like to call Ms. Jacqueline Smith. In the middle. Thank you. Jacqueline Smith. Thank you, Jacqueline. Miss Tamika Grant. Okay, so that's all of the mentors that are here. We will send the rest of their respective firms. We would now like to call the Speaker of the House, Honorable Gordon Burton, to present an award.
She's here.
Oh. Oh, sorry, we forgot one mentor. Miss Makia Mills.
These are the speakers and two boards. I'll show you the judges first.
We'd now like to take this opportunity to thank the judges who participated throughout the national semifinals and finals round of the competition. We'd like to call Justice Logan. Is she here, Karen? We would like to call Miss Justice Logan Jackson to accept this reward on behalf of Miss Justice Carrie Ann Campbell. She was one of our judges during the national rounds of the competition. We'd now like to call Miss Desiree Downs. She was also one of our judges during the nationals round of the competition. I don't take off my mask. We'd like to call Mr. Justice Shiraz Aziz. He was one of the semi-finalist judges during the competition.
Thank you very much.
Thank
Thank
you.
you, lovely. Thank you for having me.
We would also like to call Ms. Desiree Downs to accept this award on behalf of Ms. Chatalia Hallgreen, who was one of our judges during the semifinals round. Oh, there's EPP. And so Tanya, I am so sorry.
All right. Yeah.
Okay. Justice Loban Jackson. Our judge for today. Thank you. Thank you. Unfortunately, the awards for our Attorney General and Mr. Ariel Music QC, they are still in Florida. So they will be sent to you very early next week. You want to take a photo, we can get you something to take a photo.
Let them know along with some of the kids' shirts and bags. So.
Yes, we also have shirts and bags for each of our participants, but they are also stuck in Florida, unfortunately. So they will be delivered to the students at their schools. So thank you, Madam Attorney General.
Thank you.
Mr. Mizik. Thank you. Okay, yeah, sponsors. So the winners of this competition today also received an invitation from the House of Assembly to attend at one of the summer sessions. So we would like to thank the Speaker of the House, Mr. Gordon Burden, Honorable Gordon Burden. Okay. I'm not sure if a representative from Beaches is here. Alicia? Beaches Resort and Spa kindly acts as our sponsor for the nationals round of the competition. We would also like to present an award to Michigan Stambra. Acting as a sponsor of the TCI Bar Association. Thank you. What else? Okay. The one of the students from Southgate. Okay, Flow TCI. No, for the winners of this competition, Flow TCI is also providing 2 months of internet service to the winners of the competition. So we will get your details, Chelsea and Maya, and provide you with the contact details so you can be sent with the award. So I don't think we have anyone from Flow TCI here today. For the runners up, you have 2 open domestic tickets from Cakers Express. I do not see a representative here from Cakers Express, so we will be reaching out to you to get your details. We would like to call Ms. Jasmine Thomas from the Youth Department. I'd like to thank the Youth Department for being a 2022 launch sponsor of the National Moot Court Competition. We would like to call Ms. Shantae Francis as a committee member for the National Moot Court Competition. I'd like to call Ms. Aisha DeFore. Yeah. We'd also like to call Mr. Justin Kernizer. Now, Justin was the person who has provided all the tech support to ensure that all of our Moot sessions could be live streamed. Not sure if he can get away from the computer, but we will. Oh. Okay, thank you.
And I guess this is the last one, which goes to our Mistress of Moots for doing a fantastic job.
Thank you. Okay, this ends our award ceremony. So we are now inviting everyone to partake in the cocktail reception we've prepared for you. Thank you. Oh, Kehlani. Is it Kehlani? Is Kehlani? I'm so sorry, Miss Kehlani Hanfield. Is it up?
Internship will be announced. That was one more DP.
Oh, no,
No, later.
Sorry, we have one more student, Miss Kehlani Hanfield, who is from Hamilton.
Oh, Hamilton? Just give one.
Miss Kiana Hamilton, and you are also awarded with a workplace at the Labor Tribunal. She has your right certificate. Thank you. Now you can indulge in the cocktail reception. Thank you. I'll get the certificate back. I'll get the certificate back. I just need to present something.
How are you doing?
I'm good.